Welcome back to the Hot Seat essay, where we dive deep into South Africa's most gripping court cases. In today's video, we bring you the full, unfiltered breakdown of the court's ruling regarding the state's controversial application to admit over 6,000 new photographs in the Senzo Meyiwa murder trial. What follows is not just a ruling, but a constitutional reflection on fairness, justice, and what the law demands when truth is on the line. Let's unpack the judge's detailed and thought-provoking judgment. The judgment begins with numbers, cold, hard figures that represent the mountain of photographic evidence at the heart of this legal debate. The court reveals that there are thousands of photos, with over 700 linked to accused number 3 alone. In total, the joint folders include over 6,000 photographs, images that could either support or unravel the narrative presented in this high-profile murder case. Now, how and when these photos came to light is key. The court acknowledges that the state discovered this material during the court's recess, a period when defense counsel for accused number 1 was preparing for cross-examination. This preparation stretched across 4 months and 3 weeks. It was during this lengthy interval, when both sides were delving into evidence, that the state claims to have found crucial photographs that it now wishes to present. Now, one might ask, is this a case of trial by ambush? Did the state hide evidence and spring it on the defense at the last minute? The judge addresses this head-on. He reminds the court that all defense counsels were given access to the evidence, not just in passing, but in a period that spanned 2 full weeks, during which each legal team was allowed to review the images. The judge affirms, and I quote, "No person was ambushed." According to Advocate Beloy for the state, the same photographs that were recently discovered were promptly handed over to all defense teams, accompanied by a clear notification the state intended to use them. The defense naturally argues otherwise. Their position, that this is new evidence, evidence that should not be allowed at such a late stage. They contest the relevance of the photos and claim the state is trying to shift the direction of the case. But the judge is prepared for this argument. He references the fundamental legal principle that irrelevant evidence is inadmissible. Yes, but relevant evidence, no matter when it is discovered, must be allowed if it contributes to the search for truth. He reads directly from legal texts and case law, even citing page 2422b from the South African Criminal Law Digest, where relevance is defined not by rigid formulae, but by common sense and logic. And here's where the judgment takes a philosophical turn. The court explains that relevance isn't a question answered by legalese. It's answered by real-world logic. If one fact in relation to another makes something more probable or less probable, then it is relevant. And if it is relevant, it is admissible. The judge reinforces this with historical cases, R. versus Impanza, 1915, and R.V. Torpedo, 1920, rulings that emphasize the use of reason and experience in determining whether evidence should be allowed. He even cites former Judge of Appeal Fikile Schreiner, whose chance to be Chief Justice was lost to politics. And he tells us, logic and lived experience are often more important than rigid legal formulas. Next, the judge turns his attention to the accused's defense, a critical aspect in deciding whether this new evidence is prejudicial or not. The accused, from day one, have maintained a consistent defense. They claim to know nothing about the murder. They say they were not present. They deny any involvement. That defense has not changed. And so, the judge argues, these new photographs, even if admitted, do not alter the substance of the defense. There is no surprise shift in strategy, no scramble to come up with a new story. The accused's stance is unchanged, and therefore no material prejudice has been introduced by the new evidence. The judgment then highlights a powerful legal precedent. Even when new evidence is found late, yes, even during appeals, South African courts have allowed such evidence to be presented, provided it is relevant and has probative value. The judge refers to a previous case heard at the Supreme Court of Appeal, the SCA, where 5 judges unanimously allowed the state to reopen its case after discovering new, crucial evidence. That ruling laid down the principle: if the state discovers relevant, admissible evidence, even at a late stage, it is entitled by law to present it. That same logic applies here. Then comes a reaffirmation of the prosecutor's role in society, one that goes beyond simply trying to win. The judge recites key parts of the National Prosecuting Authority Act, specifically Sections 32 and 2661A. These sections demand that prosecutors act with impartiality, in good faith, and in the public interest, free from political or judicial pressure. They must not seek victory, but justice. He quotes the International Prosecutorial Standards, saying prosecutors must remain unaffected by media or political bias and must always act fairly, consistently, and efficiently. He also references the landmark 1955 Canadian case of R. Boucher, where Judge Ratha stated, "The goal of prosecution is not to win a conviction, it is to present credible, relevant evidence, and to allow justice to be served." Returning to the current case, the judge reminds everyone, the state is not pulling a rabbit out of a hat. This isn't courtroom magic, it's due diligence. The photos were discovered, they were shared, the intention to use them was declared, meetings between the state and defense took place, there was no trickery, no deceit, no manipulation, and so, based on the evidence, the law, and the principle of justice, the judge declares, this court is persuaded, the evidence is relevant, it is connected to the case, it does not materially change the defense, and the application is granted. With those words, the court grants the state permission to lead 2 new witnesses, whose testimonies will revolve around the newly admitted photo evidence. The state's next witness will be Warrant Officer LT in LVU, who was briefly delayed due to travel from Middleburg. The court is adjourned briefly, with the matter set to resume at 2 p.m., signaling the start of a new chapter in this ongoing trial. So what does this mean going forward? It means that the court has upheld the principle of fair justice, allowing relevant evidence to be heard, even if it arrives late, so long as the process is transparent and all parties are informed. It also means the state now bears the burden of connecting these photos to the crime and proving their significance beyond reasonable doubt. The trial continues. The stakes remain high. And the Hot Seat SA will be right here to keep you informed every step of the way. If you found this breakdown helpful, please like, subscribe, and share. Justice takes time, but truth must be told. Thank you for watching.